Hi, I'm Mike Caldwell. I'm the Director of the Business Innovation Zone. The Business Innovation Zone, or the BIZ, was created to help high-growth potential entrepreneurs and businesses in central Iowa. We provide a variety of services, including mentoring, consulting, counseling, validating business models, and help with access to funding for high-growth companies. We offer also a number of networking opportunities, including luncheons once a month and all-day seminars on subjects such as marketing and finance. You can find out more about the BIZ at www.bizci.org.
I'm Rush Nigut. I'm a business lawyer with the Brick Gentry Law Firm in West Des Moines. We have about 25 lawyers, and most everyone in the firm practices in some aspect of business law. What I typically do is I typically work with a lot of startup businesses, a lot of one or two-person owner companies, sometimes a little larger than that, but most of them are your typical small business. I have a blog called Rush on Business, and I encourage you to go there. I have a lot of information on entity formation, S Corps, LLCs, C Corps, some information regarding capital raises and those types of things. Typically not my stuff, but articles that I'll point out to people. When entities are formed, it's pretty funny, really, because a lot of people they agonize over this decision. Whether they're going to form an S Corp or whether they're going to form an LLC, whether they're going to form a C Corp or something else. And in fact, I had a guy come into my office one time, and I kid you not, he had a stack of books at least this high, all on entity formation. And he brought them all to the meeting. I don't know if he expected me to read them or not, but I'm not quite sure that I've ever read this many books on entity formation, although I've certainly read a lot of articles on it. But I can tell you right now that when you are forming an entity, there's nothing that you can't change down the road. Now you have to be careful, and it's very important to get particularly advice from accountants and tax advice. But if you make a decision early in your business to form an S corporation, or if you make a decision to form an LLC, there's nothing that says you can't change down the road to a C corporation, for example. One of the things that you have to initially think about when you're setting up your business entity is, what are your goals? Some people have no desire whatsoever to raise money. So when those people come in, typically I'm advising them on, okay, what entity best fits your tax situation? Because all these entities typically will provide limited liability, which is an important aspect. If you're running a business, you don't want to have personal liability for the business and if things go wrong. So that's generally what I'm doing when a person comes in to see me is, what's best for their particular situation, their own individual situation. Some of you, though, may come in and you'd say, well, I want to raise money. And then it's a different question, typically, and it's a different process that you would go through. And while someone who would come in and they may not have the intent of raising money, and we'd set them up with an S Corp, maybe that really doesn't fit for somebody that's desiring to raise money, because S Corps have certain restrictions. And some of those restrictions include the fact that you have a limited number of shareholders, typically 100 shareholders. And while it's a pass-through entity and might be great for individuals, venture capital firms or people who are looking to invest money who have companies, they can't invest in an S Corp if they have a company, if they have an LLC, or if they have a corporation. So that's something to immediately keep in mind. Most venture capitalists seem to favor C corporations as opposed to LLCs, and as opposed to definitely S corporations. I had an entity that eventually raised some money. It was a technology startup. It started as an LLC. They went out and they sought funding, got funding from about 3 different companies, and immediately we switched from an LLC to a C Corp at the request of those new investors. So that's a perfect example that you can change, and a perfect example that the investors, typically are not going to want the LLC or the S Corp. Now, if it's a smaller company and you don't anticipate getting, real large or having a large number of investors, or perhaps you don't need a substantial sum of money, and that's your typical company, really, an LLC might not be a bad thing, because somebody who owns a small company might be able to come in and give you money. Someone who wants to do that with an S Corp, it's not so advantageous for them. So there are a lot of different factors, and particularly if anyone has any questions at any point during any time in this presentation, please, by all means, speak up. A couple of the other things that I see is that people agonize over this decision of where to start their company. Someone here in Iowa, they live in Des Moines, and they've read on the internet that I should start a Delaware corporation. So that's what they want to do. They want to start a Delaware corporation. Or they want to completely remain anonymous, which isn't true, and they want to start a Nevada corporation, because that's what they've read online. But you're not completely anonymous with the Nevada corporation. Remember that right now. But most of the time, if you have a small business, you're starting up here in Des Moines, Iowa, an Iowa corporation is a great place to start because it's cheap. You have, with the Secretary of State, you have a minimal filing fee. You have minimal costs to keep it updated. It's only $30 every 2 years to keep your corporation or your LLC going. So there's no reason to go to Delaware or any of those places for your typical small business. Larger businesses, public companies, tend to have Delaware corporations, but most of us are not going to be dealing with that situation. Of over 2 million businesses that start in the United States every year, only about 600 to 800 of those companies ever get venture capital funding, and I would imagine the percentage of those companies that would ever go public, is less than 1%, definitely. So keep that in mind as well. Iowa is a great place to start your business, and maybe I should be, the economic broadcaster, but that's absolutely 100% the case. I'm going to talk about entity formation really in the context of fundraising, because I could sit here and I could talk about S Corps versus LLCs versus C Corps all day, and all of you would glaze over and you wouldn't want to hear this. So I'm really talking about this in the context now of raising money. And when you're thinking about your entity, the size of your entity, I guess size matters, and the complexity of your documents and your agreements will increase with the size of your entity. When people first start out the company, if it's an individual, obviously you don't have to worry as much about the agreements, although it's really helpful, I think, to start from the very beginning, even if you have your own individual company, with, at the very least, if it's a corporation, your articles, your bylaws, your initial meeting minutes to cover all those types of things from the very beginning. Your funding mechanisms, as you grow with your business, they all become more complex. Initially, if you're going to friends and family, those agreements may not be nearly as complex as you go to the angel investors and then venture capitalists, mezzanine financing, and on. So, but do things right from the very beginning. I've seen situations where groups of individuals will maybe file articles of incorporation. They won't prepare bylaws. They don't prepare a buy-sell agreement. They have no meeting minutes that reflect what the agreements are. And then you can run into problems with, if it's a tech company, for example, or some type of company that relies on its website. Maybe one owner bought the domain name. Okay, so now we have an argument. Who owns that domain name? It's in the owner, one of the owners, it's in his individual name. How do we get that back into the company? How do the other owners make sure that they have the rights to that domain name? Or does that owner just walk away and say, well, it's mine. I'm done. So that's something to keep in mind. I see that frequently, domain names. And my advice to anyone is if you are starting a company, buy your domain name yourself in your individual name from the very beginning. Because if you let some web developer or consultant or maybe another partner who maybe is a minority partner, all of a sudden they have a trump card over you. So either you, if you're a majority owner, you buy it, or you make sure that the company owns that domain name. Many of you may have technology type companies, so you have software. Who's writing that software? Is it one of the owners? Is it a minority owner? Who owns that software is a critical question. And as a part of that, you want to make sure, again, that you have an agreement up front with the developer, whether he or she is an owner or not, about the ownership of it. If that person is not an owner, because this happened to one of my clients, she developed a terrific software in the nursing home industry. Well, she didn't write the code herself, someone else did. She hired this person, and he had worked with her for at least 10 years. It came to the point where she's going to sell her business, and she, in fact, had first drafts of agreements written with the company that was buying her business. And all of a sudden, this software developer says, this is my code. I never transferred it to you. There's no indication that it's your code. I want part of the deal. So you can imagine how she felt at that point and the hostility that she felt towards him and the trouble that it presented for her deal. Now, fortunately, we were able to work that out, but who owns things is just a critical aspect when you're setting up your businesses. I hear that at least almost every day. There is no such thing as a 1099 employee. Either you're an employee or you're an independent contractor. And if you're an independent contractor, that's the 1099. So thanks for saying that, though.
Sure.
If you have a contractor, if you have an independent contractor, someone who's 1099, then you definitely want an agreement with that person. And you want to make sure that all those rights flow to you. And you want that in a written agreement. If you have an employee, it's not required that you have an agreement with the employee, because if an employee is working for you during your time, during work hours and all those types of things, then if they're employed by you, that's your intellectual property. Now that's the basic answer. The answer to really, really protect you, though, is that you should have something, either in an employment agreement or in your employee manual, that states that that intellectual property that they are developing for you is owned by you. Under the law, employees, though, but the question becomes, well, if they're working outside of work hours, that could present problems. Or maybe they develop a modification of something that you own, and they do it on their own time. Who owns that? So it is very beneficial, and it's important to have agreements up front with employees as well, or at least some type of provision in your employment manual that will cover that. So that's a really good point. When we're moving towards more of the, how do you value entities? Because lots of times, I'll have 4 people who will come to me, let's say, and they say, well, Joe's putting in 10 grand, and Frank is putting in 5, and Mary is contributing her software, and Sally is just kind of along for the ride, but she's going to help us out. How do you value that? How do you place a value on everyone's shares? How do you place a value on their contributions? And when you're starting out, there really isn't a good answer. I have it all over the board where some people will just come in and say, well, my company's worth $200,000, and here's how we've valued it. That's very common. They just pluck a value out of the sky, so to speak, and that's what they go with, and that's perfectly fine. Because in the beginning, unless everyone is putting in the same amount, and you can kind of figure out what everybody's percentage is based on their capital contribution, it is difficult to determine what is your company worth. So as we move more towards a buy-sell agreement, which Mike is dead spot on when he talks about buy-sell agreements, if you want to find out if you have a partner, negotiate that buy-sell agreement up front. I had a company of 4 people. It was absolutely the most uncomfortable meeting I've ever been a part of in my professional career, when we all of us sat down in our conference room and we started talking about the buy-sell. And 2 of the people wanted a higher percentage than they had talked about previously with the person who was not the majority owner, but owned the most shares. And she stood her ground and she said, absolutely not. I am not giving anyone else any higher percentage. And you should have seen the looks on their faces. And it was just it was really an incredible dynamic. Eventually they talked it out, and I'm convinced to this day, if they had not had that conversation, that they would have fallen apart in just a few minutes. But it really was a good conversation. And so they all learned what was important to the other people. And so that discussion is critical. You don't have to have an attorney present. Absolutely not. That one happened to be, it was kind of impromptu, actually. It wasn't a part of our discussions initially. It just kind of came out. But you don't need an attorney present. And in fact, I encourage you, to the extent possible, negotiate your deals without an attorney up front, and then have your attorney memorialize that agreement rather than be a part of that process. Although certainly we can lend advice and help in that regard, but you got to have those frank discussions, I think, with your partners. And I should have said up front that really my advice to you is set up your entity in your own individual names. Never give anybody else shares. Never go out and raise money. And absolutely never, never, never get a partner. Okay, so you can all go. But you're all going to, most of you are going to ignore that advice. I've ignored my own advice time and time again. And so I guess we need to talk about this. But I think what works best a lot of times is that you have that discussion with your partner. Some of the basic overview discussions where how are we going to value this business? That's a question that that comes up all the time. Is how are we going to value this? Are we going to have a fixed price? And what that means is this business is worth $100,000. And lots of times what you'll see in an agreement is we're going to pick a fixed price every year because that price would change over time. Well, that doesn't happen in reality because people forget, people neglect to do it. So a fixed price, while it would be perfect if we could just say, well, the business is worth $100,000 or $1 million or whatever it is, in reality it just doesn't happen. So that's something that have that up front. And some of these considerations that, am I going to have a fixed price? A formula. I've seen formulas that are as uncomplicated as, it's 1 times the last 12 months gross revenues. Very simple. So you take the percentage of that owner and you determine the price by taking it times the last 12 months of gross revenues. Or maybe it's 4 times or 6 times. I mean, there is no set formula. It varies by industry, and it's best to get some background research on your own to find out how companies in your industry are valued. Perhaps we have a shotgun approach where one of the owners will say, here's the offer, and the other owner will say whether or not they're a buyer or seller at that price. So typically that might encourage someone to pick a fair offer. You have all your buy-sell agreements really should include a right of first refusal where the inside owners will get an opportunity to buy from a selling owner before any outside owners. So that's critical for particularly small businesses that want to control who owns a part of that company. And then there's the appraisal method, which for appraisals, this can be very expensive. It can cost up to $10,000, for example, to have your business appraised. And so you want to think twice about whether an appraisal method is right for you because it is costly. And often it is a process that can be a little cumbersome because you'll have someone who will have the right to have the business appraised. Then the buyers will have the right to have their own appraiser. And if they can't agree, then we'll have a third appraiser. That's a common method. So that can be very expensive. It can be cumbersome, and it leaves open a lot of potential for dispute, I think, sometimes. But the formula method, I think, if you can come up with a formula, is a really good way to go about that. Some of the other things that you need to consider is there a dominant owner? Is there someone who owns 90% of the company as opposed to a minority owner who may own 10%? So minority owners, they will need to potentially purchase over time, and you need to look at aspects of how to go about funding that. Life insurance may be necessary in that situation. If you have owners that are more on equal footing financially, often you won't have those problems. particularly early in the stage, but as your company grows, if you're making significant revenues, it may be difficult for an individual owner to come up with the money all at once. So that's an aspect of, if you have unequal ownership, it's something to consider. The ages of owners are very important. Most businesses, almost I would say probably 95% or more of businesses do not plan for succession. It is so rare that someone plans for succession. It has immense benefits, obviously, if you can plan for succession. And even young owners, occasionally something will happen. And we had a very unfortunate tragedy here in the Des Moines community that, where a marketing firm, they had several people who were involved. I think it was a plane crash, and passed away. I was not involved in that situation, but if they didn't plan for the future, there were potential problems there. So keep that in mind, even for young people. I think some of the real benefits for planning, first of all, you can agree on a price. I mean, isn't it nice when, if you're going to hand off the company, that you can say, all right, here's the price, and you write the check, or at least you have the agreement in place to pay for it over time. So that's the first thing, you agree on the price. The second thing, and lots of times if you have a buy-sell funded properly, the payment is immediate or more immediate than it otherwise may be. So I'm a big believer in, no matter what it is, if I can get my money up front, that's what I want to do. So if you're a majority owner in particular, you want your money and you're out at that stage. The other thing that is of significant benefit is if you don't have your buy-sells properly funded in some way, or a plan and an agreement, is that your company, if it has poor cash flow, or if the minority owner cannot purchase the business, then you might become a takeover target, and it's not going to stay within your group, and you might have to sell to a third party, and that may not be a desirable result for you. So, those are all critical aspects to look at. Review your agreements annually. If you have a buy-sell agreement, and I am going to talk more specifically about what will be in buy-sell agreements in the partnership section of this, but review your agreements annually. Believe it or not, I mean, most people, they stick them in the drawer, and they don't look at it for 10 years, and then they say, they call up the lawyer and say, well, do you have that buy-sell agreement that we can take a look at? And I've even seen it where individuals don't even understand, first of all, why or even what their formula means anymore. It makes no sense to them whatsoever. I've seen it happen. That the formula they wrote 10 years ago to value their business doesn't have any reflection of what they would want today or even understandable to them. And I've seen fights that happen over that. And you're like, well, what do you mean you don't understand the formula? But they literally, the way it was written, could not comprehend what they had written, why they had written it, or how to value their business, and they had a fight, that way. And then, obviously, update it, if it no longer meets your needs. I recommend that everyone, and there are other professionals obviously, typically when I give this presentation, marketing professionals raise their hand. You've got to have a marketing professional for your business. But these are the ones, when we're dealing with capital raising, when we're dealing with your legal agreements, have an attorney, have an accountant, get an insurance professional. Business valuation expert can be helpful. Hopefully, usually I think it's a good idea to have an accountant who is really well-versed in that area. It's very important. And, so much of this is tax-driven. It's not that it's, from a legal perspective, we're trying to avoid problems. We're trying to avoid litigation because the litigation costs can be so high. But for owners, a critical aspect for you are taxes. So make sure you get a great accountant. And now the LWBJ firm owes me, for that too. But well, non-disclosure agreements. I know there's a guy over here that will say when you're dealing with venture capitalists that non-disclosure agreements don't mean a whole lot. Number one, and number two. The venture capitalists, it's naive for you to think that they haven't seen what you're presenting them, and they probably saw it in the morning before, and they'll see it after you, and a lot of them won't sign them. From a legal perspective, because I'm a lawyer, and I'm not like him, I recommend that you have it. And so if I'm presenting an idea, I want my client to have a non-disclosure agreement. Now, more than that, though, I want my client to be able to accomplish what it is that they need to accomplish. So if it's a venture capitalist who, it's very unlikely that they're going to, steal your idea, and it's probably, if you were successful in dealing with them, it would mean tremendous upside to your company, then by all means, sometimes you're going to have to take that chance. But my feeling on non-disclosure agreements is that if you can have them, do it.